Hi, everybody. Thanks for joining us. My name is Rollin Schuster. I'm the managing principal of the Schuster Group, president and founder of TANGO. Greatly appreciate you guys carving out some time to learn about the Connecticut Paid Family Medical Leave Act. So this is part 3 in our series. We're structuring this a little differently, and we encourage interaction. So if any of you have questions as we go through this, feel free to turn on your mic and ask a question. There's a chat feature on this Zoom as well. Feel free to type your questions in or comments in, and we have a great crew here to address any of these questions. So before we go on, I just want to introduce who we have with us today. Gil Keegan, he's our sales manager at the Schuster Group. Ryan Lawless, a senior consultant, does a great deal of work focused on the nonprofit space. Tricia Reilly, a partner at Murtha, Cullina, a law firm in Hartford and beyond. And Randy Petersen, a senior consultant with the Standard, a top-tier insurance carrier that's spending a lot of time focused on this space. So I think we have a really good cast of characters, if you will, to hopefully make sense of this. The prior 2 sessions focused on kind of a deep dive on the Connecticut paid family leave from the state perspective. We had Andrea Barton-Reeves, the director of the Connecticut Paid Leave Authority. And then our last session, we had an attorney from the Guardian looking at this from the private standpoint. And today our intentions are to bring it all together for you guys. So Joe, if you could flip the slide, please. So I want to give everyone a quick recap of the Schuster Group. Most of you know us. Many of you in the audience we've worked with for many, many years, and we appreciate that trust and confidence you've bestowed in us. We've had some interesting and very exciting things happen to us over the last several weeks. So just by way of history, the Schuster Group, we're 29 years old. We've had consecutive growth each and every year. Our focus is in the retirement, employee benefits, insurance, and advisory services. We are very much focused in the nonprofit space. The vast majority of our clients are in the nonprofit space. And it's one of the reasons I created TANGO, to bring scale and leverage to the sector, where we can blend our business attributes with really doing some goodwill for the nonprofit sector. We now have over 1,400 nonprofits in TANGO, representing over 160,000 people that work in the sector. So that scale and that market knowledge has given us an edge out there to develop products and programs, not only from us at the Schuster Group, from all of our partners. And then we've been an NFP benefits partner firm since 2005. I've been on their advisory board for the last 7 or 8 years. NFP is a national insurance and financial services advisory company. And towards the end of last year, they were paying a great deal of attention to us, to the point that they wanted us to join them, merge with them, if you will. So we are now an NFP company, and we are going to be running the Connecticut marketplace into Western Mass. None of our staffing is changing. Everyone is staying the same. We just have the resources of a very, very innovative, big firm. So it's great for our staffing. It's great for our clientele. And you're going to see more and more resources being brought forth to the market as we get this merger together. Quick update on NFP. There's 5,100 employees, 250 offices across the United States, Canada. They are now also in Europe. Second largest retirement plan aggregator, 6th largest employee benefit broker, 10th largest property casualty agency, and a great deal of focus on the executive benefit market. So we are just thrilled to be part of this group. It enables us to take what we've built over 29 years and really capitalize that and bring something, I think, truly special to the Connecticut marketplace, especially as it relates to the nonprofit sector. NFP is very excited about TANGO and helping us expand our footprint throughout the region and nationally. So, TANGO is one of those things. The bigger it gets, the more we can do. So a lot of good news here. some of you already know the news, but there'll be press releases coming out and some stuff in the paper. But just wanted to give you a quick update. It's all good, nothing to worry about. Just more capabilities, more resources on our team to support our clients. Next slide, please. So today's conversation is focused on 4 primary things. We're all seeing this is sweeping change. You know, those of you guys that are in the audience that are in the HR space or the compliance space, I think we can all agree the world is continuously getting more complex. And this law adds a whole nother layer of involvement and complexity to your already busy days, right? So what we're going to talk about today is the compliance aspect of this and the process, managing this whole thing. What you should be thinking about with respect to benefit design. Does it change a broader picture of what you've historically been doing? Cost structure, we want to comment on that a bit too. And then what impact does it have on your nonprofit's culture? We think there's, it warrants this conversation because this is going to change the way, in many regards, you're managing your workforce. We have commentary from really 3 angles, as I mentioned in our introductory, in our introductions. So the standard, Randy's going to be talking about this from what he's seeing as one of the lead carriers in this space. So kind of one viewpoint. Tricia is going to be talking about the legal aspect of this and what she's seeing out of her office as employers are getting their arms around the legalities surrounding this new law. And then we at the Schuster Group are going to be talking about what we're seeing in our day-to-day work with clients and how it impacts their benefits, their culture, costs, the programs that are out there. So this should be a pretty engaging conversation. And at this point, I'm going to turn it over to Gil Keegan. We are going to go through a recap of the regs, not getting too far into the weeds. You guys have probably, if you've been to our prior 2 sessions, you've gone through this. Most people I talk to have gone through 5, 6, 10 of these type of sessions from a variety of folks giving them. So we're not going to spend a ton of time on the regs, but we just want to set the stage as we get into our conversation. So Gil, if you can add some commentary and walk people through where we are with the Connecticut Paid Family Medical Leave Act, that'd be great.
Yeah, thanks, Rail. Next slide, Joe. So as Rollin said, I think probably most of you have seen this and are aware of it, but a couple of different types of coverage, first of all, and the durations here. So for purposes of family leave, 12 weeks is kind of the norm for bonding with a child, caring for a member of the family, military reasons, and any organ or bone marrow donation. The duration for that coverage is 12 weeks. For any issues that surround family violence, it's a 12-day window. For medical leave purposes, same thing, 12 weeks, unless there is an incapacitation or issues around pregnancy. And if so, then that obviously is an additional 2 weeks that go there. So reality is a combined max, whether it's family leave or medical leave combined, the maximum benefit is that 12 weeks with the additional up to 2 weeks for incapacitation for pregnancy. They do allow for intermittent leave, so you can take portions of this throughout the course of the year. It does not need to be taken in a 12-week lump sum. It can be taken throughout the course of the year. For those that are covered, kids, parents, spouses, grandkids, grandparents, siblings, and my favorite, any person with close association that it seems to be equivalent to also, someone you can take leave for to support in those instances. So, Joe, the next slide. So when does it start? Really, it starts day 1. So the first day in which there is an event that occurs, the benefit does exist on day 1. As far as wage replacement, it's up to 95%. So 5% of an employee's earnings are replaced up to the first 40 times the state minimum wage. Following that, an additional 60% of earnings over the 40 times the minimum wage to a maximum of 60 times the state minimum wage, which today, based on minimum wage, is a benefit up to and not exceeding $700. The funding of it is done through deductions. It's 0.5% of wages. It is funded completely by the employee. Employers do have the option, although we're not really seeing many do that, to pay a portion of that premium, but this is meant to be 100% employee funded benefit. Next slide, Joe. So from an employer perspective, really it's employers that have or more. It is obviously towns, Board of Eds, and independent schools are three kind of categories in which this law does not apply, but any other business that employs at least one person, this benefit in this law applies. From an employee perspective, you need to be employed the last 3 months to be able to request a leave. You need to have earned at least $2,325 in at least one of the last 5 quarters. There's no minimum hours required, and obviously your job is protected during the course of that leave. A couple kind of quick things on the private plan. If you do have interest in the private plan, you do need to register as an employer with the state. You do need to host an employee vote. You need to get 51% of your eligible population saying that they approve you going to the private plan market. That vote can be done in various ways, and we can discuss that later. And you do need to file your private plan application with the state, which includes the declaration of insurance. And then the last slide, Joe, on the regulations really is just a timeline. And I think this is probably pretty clear and pretty obvious. Deductions started on 1/1/21 for the state plan. The deadline for private plans is the end of March, so March 31st, 2021. State plan contributions are due April of 2021. And then again, the benefits for this will begin on January 1st of 2022. So that's kind of a recap of the basics of the regulations.
Hey, Gil, does it make sense just to take a breather here and see if anybody has any questions on the just straight regs? And
yep.
Tricia or Randy or Ryan, any color commentary as it relates to just the regs?
Yeah, I'm just going to chime in here that it's going to be very interesting to see how this Connecticut paid family leave interrelates with other existing leave laws. And I won't get into great detail about it, but the good thing that everybody needs to know here is that the existing Connecticut family medical leave, which is unpaid, is changing so that the benefits and the length of time are coextensive with the paid leave. And by that, I mean, to get the Connecticut unpaid leave, you do have to be there for 3 months. To get the Connecticut paid leave, you only have to be there for, a day. But you can run them concurrently. So you don't have to worry about the 16 weeks in a 24-month period anymore. So it's all going to be integrated. As we all know, federal leave is also 12 weeks, but there are stricter requirements for compliance, 1 year and 1,250 hours of employment. So I think in some ways it's going to make administration of FMLA easier with regard to the counting and all of that. But the big change here is an employee is entitled to Connecticut paid family leave as long as they've met that threshold of a very minimum, just over $2,000 threshold of having of compensation, and they could have earned that at a different employer. So you could have somebody on day one coming into your employment who says, I want to take my paid FMLA, and you'd have to provide that. However, paid FMLA alone doesn't require job security versus unpaid FMLA does. So there are all these issues about the integration of existing leave laws, and I'll just leave it at that. And if anybody has any questions, you know, as we proceed through the program, feel free to raise them and we'll try to address those.
Thanks, Tricia. A hotbed of situations are coming our way. So
can't wait for the questions. Once it starts getting implemented, it's going to be, we're trying to make it as clean cut, as understandable as possible, but it will present challenges to employers for sure.
No doubt. Joe, you want to flip the slide, please? So we're going to talk a little bit about cost and performance. So all employers have the option to go with the state plan or go to the private market to secure this type of administration. We're looking at costs and have been over the last few weeks. In some situations, the private market has been more competitive, in others, not so much. The administration, you know, we don't know yet what the state's going to look like, right? They're taking on an enormous task, and how they're going to be able to handle the claim processing, the administration of approving people for leave, all that kind of stuff is a little bit of a mystery. The private market has really geared up and is starting to do some things there because they've been doing it for decades. So we're going to talk a little bit about that as we go forward into the next few slides. Internal administration versus outsourced absence management. This is becoming a really hot topic. I know from talking to you guys, HR folks, that your lives are not getting any easier. I mean, every year it seems like there's another set of laws or requirements or reporting something or other that needs to be done. In a nonprofit setting, recruitment, retention, all those sort of other HR functions are not that easy as well. You start to layer on complexities around these laws, and we're starting to see an emergence of outsourced absence management. And then you obviously have to look at the cost of that. Does it make sense fiscally? There's a cost to do it internally, and there's a cost to do it outsourced. There's risk too. In managing these plans, there's a fiduciary obligation you have to make sure you're doing things right. And who is best suited to do that? Internal or outsourced? So we're going to get into that part of the conversation now as we start to see the market evolve and products emerge and capabilities emerge to help employers manage this complex arena. Joe, if you could.
Hey, well, real quick, this presentation is being recorded too. So, you know, as you're thinking about internal versus outsourced on that last slide, you can go back and listen to what Tricia said 3 or 4 times, you know, what she just said. And you know, because I know that brought up even questions for me, and we've been studying this and working on this for a while. So
great point. So Randy,
Yeah.
From a carrier perspective, what are you seeing going on out there? And I know the Standard did a really interesting study. Maybe you can kind of rip through some of these stats and set the stage,
Yes.
and then get into some dialogue as to what's happening with one of the market leaders being the Standard in this space, and just some of the trends you're seeing.
Sure thing. Thanks, Rollin. And first and foremost, I want to thank the Schuster Group for having the Standard as part of the panel. It means a lot to us. We have a great relationship with the Schuster Group. For those folks on the phone who likely or possibly aren't familiar with the Standard, we're a life, disability, dental, vision, supplemental product carrier. We've been around since 1906, and I've been with the Standard for 28 years, only real job I've ever had. So when things like Connecticut PFML come up, it's our responsibility as a company and my responsibility to let the Schuster Group know what we're doing. So how does that translate to those of you who are on the phone right now? I think about it a couple different ways, Rollin, because I think that there's cost considerations for whether or not an employer considers going with a carrier. And there is a list of carriers on the Connecticut PFML website who have committed to the market for having private, fully insured Connecticut PFML plan available to policy owners. And I'll give kind of like a high level example before we dig into some of these statistics. So if Standard Insurance has the short-term disability for a policy owner, what we're doing right now, and Tricia, she unveiled a wealth of knowledge in a really short period of time talking. It's that kind of sheds light on what it must be like for an employer to try to have to navigate this. And you get up every day and you're a nonprofit that's focused on some type of social service, and you're trying to get your arms around what this Connecticut PFL means. So as a disability carrier, what we're seeing, Rollin, is we get a Connecticut PFML census, we send it to our underwriter, and then we provide it back to, for example, the Schuster Group, and we say, for ABC Company, here's our Connecticut PFML rate, which might be at 0.5, it might be slightly higher. But what we're telling folks is, pay attention to the fact that if you go with us and you declare prior to March 31st, you don't have to pre-fund for 2021. So if we're a little bit higher than the 0.5, going 12 months with us might actually end up less than 24 months going with the state. So there's, employers are trying to get their arms around that. And oh, by the way, you have short-term disability with us at a rate of X, but as of January 1, 2022, because of the Connecticut PFML offset, because it's dollar for dollar, all of a sudden your STD rate, your employer paid short-term disability rate, will go from X to sometimes 30, 40, 50% less. So that's one example of what we're seeing on the carrier side day to day. And this is all ramped up probably in the last 8 to 12 weeks, even though our underwriters and actuaries and compliance department have been in touch with the state, because we saw what happened with New York, we saw what happened with Massachusetts, and now we're seeing it here at home in Connecticut. So that's a kind of a day-to-day example, Rollin, of some of the cost implications that we're seeing. Employers are having to then decide, well, we thought we would just go with the state. It's the lowest hanging fruit. It's the most simple path. But perhaps there's more into it, because if you can save money on your short-term disability and have all of these benefits with the carrier with whom you already have a relationship, and perhaps the Schuster Group is the broker, the consultant that does that, some logic there. And then there becomes, almost on a bigger level, what are carriers thinking about when it comes to full-blown absence management? And so what is meant by that? When I say absence management, what does that mean for an employer, an HR person, a benefits director of a nonprofit who might be on the phone right now? Years ago, if you had your life disability coverage with a carrier, that's all it was. It was pay your bill every month. If a claim comes up, I'm going even back to the days of faxing things and way back when. And now with these state mandated leave plans, it's far more complicated. And so what you end up with is, for example, on this slide, there's just so much for an HR person to consider. And is there confidence in the ability to keep up with every state in which you have employees where they work? And what about those changing leave laws? Because they do change. The regulations, they do change. Tricia made reference to it. There's, how the plan looks today, the goalposts might get moved in terms of when paperwork needs to be filed and when declarations need to be filed. So what we're trying to do as a carrier is make sure that an employer knows all the services that are available to them. So here's what I mean by that, by a live example. With a lack of confidence and compliance, Standard as a company, for example, looked at our block of business, and we've always said that we'll do full-blown leave management for an employer of 500 or more employees. Then we came up with and that's what we call absence management, our FMLA administration. Then we moved that benchmark down to 200 lives and developed an FMLA select plan to help employers, to help directors of benefits manage that process. So for STD, for FMLA, for LTD, there's one company that they're working with. Now, with the advent of Connecticut PFML, Standard has actually lowered that threshold to 50 lives and above. Because what we're seeing in the reality of the situation is that employers have so much on their plate, and there's exposure and risk. They have to weigh, what do we do? How much risk is there if we try to manage all of this internally? What resources do we have to do that? So, so Joe, if you could flip to the next slide, please. That would be great. Okay, thank you. So when we think about, I made reference to the fact that there's risk out there. 3 out of 4 employers deal with some kind of FMLA complaint or lawsuit. And the lawsuit that is possibly at risk could put an employer when the average settlement is over $300,000 and you're simply not prepared. Rollin earlier made reference to fiduciary responsibility. If an employer has an opportunity to shift some of that risk over and let an insurance carrier be that partner, there is some onboarding requirement. There is a deepening of the relationship that takes place, but hopefully the counter to it and the benefit is in the long run, you have a carrier that has a compliance department, an underwriting department, absence management specialists who do it every single day. And so that benefits director can focus on making sure that the employees of that employer have their full suite of benefits available to them, but specifically when it comes to leave, they have a place that they can go for it. And it doesn't mean it's going to be a magical fit for everyone. And to be clear, Standard is not the only carrier that has lowered our benchmark. Some of our competitors are doing the same thing because the need exists and the capabilities, the systems that we have and other carriers have, they exist now. They didn't a few years ago, but now they are there. So, so I want to kind of hit a pause there. There's a couple more slides that I do want to touch on, but just want to see if there's any thoughts that come from anybody that's on the phone, or if Rollin or Gil or Ryan have anything that you want to either ask about or add at this time before I go on to the next.
Hey, Randy, from a pricing standpoint, we're starting to get some proposals in, and we've had a couple that are actually less than the 0.5% that the state's charging.
Yeah.
In this industry, being nonprofit, oftentimes there's some underwriting loads or what have you that go into it, depending on the workforce and pay scales and et cetera, duties. What are you saying? Are you saying in statewide with all the business you guys do here in Connecticut,
Mm-hmm.
are you starting to see some traction with respect to employers migrating towards the private market?
It's a great question.
Yeah.
Yeah. I'm sorry, go ahead. Sounds like
No, just wondering what kind of volume you're seeing right now with respect to uptake on the private market plans.
Yeah, at the risk of, it's a great question. At the risk of sounding like a typical sales rep, I've seen all of it. I've seen some of our own proposals for Connecticut PFML come in slightly below the state rate, matching the state and above. The majority of them are falling in between matching the state and going up to anywhere from 25 to 30% above the state rate. Again, with that caveat that if we happen to have short-term disability there's some pretty significant savings that will apply. And again, they don't have to pre-fund if they go with the carrier. So I've actually been encouraged because I think the communication we got from our home office when the Connecticut plan was first announced was, wow, that 0.5, that's going to be really hard to counter against. If we're gonna commit to the private fully insured market, are we going to be able to financially compete to give our policy owners a valid resource other than the state? And I would say thus far, we've been pleasantly surprised. And to take that a step further, we've had some policy owners of ours already commit that they're going to file a declaration with us to go with the standard. So I would imagine that there's some other carriers experiencing the same mixture.
Hey, Randy, can you give us a little color commentary around any success you've seen out there regarding the vote? So as everyone knows that this isn't just an employer decision because it's employee money. The state felt that they should have a say on who administers this program. So,
Mm-hmm.
That's not an easy task either, right? It's outreach to all your employees, it's corralling them to vote on something that many don't fully understand. So any thoughts on that?
Yes, so a couple that come to mind were fortunate situations where we were matching the state rate, and the communication to the employees from what we were told was, we've got great news. We already have these specific lines of coverage in force with our carrier called the Standard. They're matching the state rate, and as a result, we're also going to get some savings on our short-term disability as of January 1, 2022. We're asking you to vote, and it's that 2-week period where they, notify them, and then they have to have the vote. And so far, the circumstances where we've been notified that the vote came back was actually almost a full commitment by the employees as well. And we also had one employer where they didn't get everybody to get back to them right away with the vote. So they, each employer, that's a whole wrinkle that I think employers are gonna have to get their arms around as we get closer to March 31st. Because here we are already at February 4th. So getting that information out there it's another layer to the process.
What actually surprised me a little bit was the appetite that the private market carriers have for this. The 16 carriers that have been approved for the state, and so there's clearly a perceived market opportunity for the private market. So it'll be interesting to see how this evolves over time.
I agree.
I've talked to quite a few folks that have some suspicions as to whether or not the state will actually be able to administer these type of plans effectively. They're new at this, where you guys have been around 100 years doing this. So yeah, it's just going to be an interesting process to see how this market evolves, for sure.
Absolutely. And that actually can lead to the next topic, which is continuing the discussion of what it means to outsource. So Joe, if I could ask you to flip to the next slide. So when the outsourcing takes place, I think we've done some surveys at the Standard, and with our policy owners that have disability coverage with us, there is, especially as time has gone by and the state mandated plans have become more prominent and continue to, the survey results tell us that there's just a lack of full confidence in employers feeling like they have the ability to manage it all the time. So if there is a prevailing feeling by the employer community that they could do better at it, we feel like that's kind of our responsibility as a disability carrier to step in and provide those resources. So typically what that means is, the reality is a per employee per month charge for us to provide a suite of services that, again, give the employer one place to go for management of the leave, the short-term disability, the Connecticut PFML, the long-term disability, and the different type of leaves that fall under the umbrella of the state plan. In addition to that, there's communication, there's reporting, there's emails that go out to keep the employer involved and part of the process so that they're aware of what's happening with a specific individual's leave. But if you think about the opposite of that, if an employer decides they want to try to tackle it all on their own, that's why you see some of the numbers from this survey on the lower side and not closer to 100%. It all has to do with confidence and the ability to manage it. So Joe, if you could flip one more, please. So when an employer decides that they do want to engage with, whether it's Standard Insurance or another carrier, there is what they have to acknowledge is that in some respects, they're handing over the keys to disability, leave management, absence management. And you're saying, we've got trust And we've got confidence in you as the industry expert to do this job for us. And I mentioned earlier that when a nonprofit, when the employees get up and go to work every day, and specifically the HR folks and the benefits folks, to think that everything you have to deal with and everything that you have to tackle on your to-do list for the day, if you were to add on top of that, constantly evolving, constantly changing leave laws, regulations, filing requirements, follow-up procedures, communication responsibilities, it can be relatively intimidating. Some have the infrastructure to handle it. Some have folks that have the experience to deal with it. Our take as a carrier, and again, we're not alone in it, is that this is what we do, this is what we specialize in, and we have people of our own that when they get up and go to work every day, their job is to be experts in this. So for example, I'm the sales rep who works with the firm like the Schuster Group, but at the Standard, we have an entire department of absence management consultants, and that is what they do. So the onboarding process is handled by them, the implementation process is handled by them, and it's intended to give the employer not only confidence that the leaves are going to be handled the right way, but that it will be handled efficiently. There's fiduciary responsibility on our end to handle it, and that also then allows the nonprofit to focus on what they need to do to be a nonprofit. And ultimately, what's that's supposed to do is lead to increased productivity and allowing folks to focus on what it is that they want to do every day.
Randy, this is Tricia, can we get back to Rollin's question about how would you advise employers to get the buy-in from their employees that they would need to outsource this to a private carrier? In other words, do you have a form of consent? I mean, because wouldn't you agree that they would have to show, that there's specific written consent to this? And to me, that process of how to get that kind of buy-in is we haven't really fully thought that through yet. So I know I'm going to be getting questions from employers about how do we even talk to our employees about that, and then how do we show that there's got to be unanimous consent? Isn't that right?
Yeah, it's a great question, Tricia. Thanks for bringing that one up. So far, the employers that have approached us in our office, what we've done is actually given them some of this information here to the benefits directors and the HR staff so that they can let their employees know. I think the few examples that we've had so far, and again, at February 4th, I think we're still infancy stages in decision making. But the few that we've had, Tricia, what they were looking for was, can you give us some statistics and some information about how we can tell our employees that we want to do a Connecticut paid family leave commitment to the carrier, but why it makes sense to do so, and some of the services that you provide and how you'll help us make it a better experience for them. So at this point, it's been a little high level. We have a declaration form that has to be completed by the employer that requires confirmation that the vote is taking place and an employer signature that they submit to the state on our behalf so that they can get that declaration done. But Tricia, I think you're right. I think that the vote is probably, of the states who have rolled out this type of plan so far, the vote requirement in Connecticut is has the biggest asterisk associated with it, because it's not simply an employer saying, yeah, we want to do this, or yeah, we just want to go through this state. Because if they do entertain going with a carrier like Standard or someone else, that vote is necessary, the 50% plus one, and they can't get around it.
Oh, okay. Thanks for that clarification. It's 50% plus one. It's not unanimous. Okay. So, I mean,
Right.
At least that's a lower threshold,
Right.
and that's a doable threshold. But to your point, the most important thing is for the employer to educate the employees about why this would be beneficial to them. That makes a lot of sense. Thank you.
Yes, sure thing.
And Tricia, it's 50 plus 1 of the eligible.
Of the eligible, right.
So if you've got 100 people are eligible, you need 51 to say yes.
Right.
Not
And
just
anybody
responses
that,
you get.
and anybody that doesn't vote, it's considered a no.
It's a no.
Which is another dynamic that makes it even more complicated, because as you try to keep in mind the Connecticut PFML census, the data that we receive as a carrier and then submit to our underwriters, it's not benefits eligible, right? It's anybody that has worked in that. So to Ryan's point and Gil's point, no response equals a no, makes it more challenging, even if the employer really wants to move ahead with a private, fully insured plan.
Hey, Randy, I have a question for you. So if when you look at like, Massachusetts, I guess, is maybe a good example, but if someone chose to go with the state plan or vice versa, and next year, either they want to change. So let's say they go with the standard and next year, Anthem's offering them a discount on their medical to move short-term disability, move everything, right? And they want to move the absent management. Is what data is available, and do carriers require that data? And then also if an organization just went with the state this year, let's say they couldn't get the vote, and then next year they're able to get the vote and they want to go to a private carrier, does the private carrier have access to the data from the state or from the organization?
So when you say data, are you talking about
utilization, call it, right?
Yeah,
So
claims information and that.
Yeah.
So it's a great question. When I spoke with Rollin a little earlier and with Gil, let's use the example of a group decides that they want to go with the standard, and they file their declaration before March 31st, and then a year from now, they're thinking that it's actually not the best fit for them, and maybe they want to go back to the state for whatever reason. As of now, I don't know. Our compliance department is still daily basis in touch with the state. I don't know as of right now what that looks like. Or as a follow-up, I don't know, will we have access to the data if it's a reverse situation, if they decide to go to the state, but then a year from now, maybe we have the life STD and LTD, and they decide, oh, you know what, we would like to go to the standard for 2023. I don't know what that looks like as of yet, but it's a homework item for me to get back to Rollin and to Gil and to you. So unfortunately, I don't have that info right now.
Hey, Tricia, you run the labor practice group at Murtha. So, I've heard from some of our clients that this is like the straw that's going to break the camel's back. There's enough regulations out there confronting HR that this is just one more. What's the enforcement environment, or what do you speculate? How tough is the state going to be in looking at compliance on this? And I'm sure you deal with compliance-oriented issues all day. Any thoughts on that?
Yeah, that's a great question, Rollin. And in fact, the Connecticut paid FMLA does not have a private right of action. So that is a really good point. However, any employee who believes that he or she is not getting their rights under this program has the right to go and complain to the Department of Labor. So it's the Connecticut Department of Labor that will be handling all of the compliance, all of the complaints. And I suspect they're going to have to hire more people for this in January of 2022 to handle the implementation and any complaints that come in on this, because they're going to be very proactive and aggressive in making sure that employers comply with it for sure. The state unpaid FMLA still has a private right of action, as does the federal FMLA. Now, all of these things can run concurrently if the person is eligible for all of the programs. But, and so to my earlier point, in terms of compliance, I mean, employers who already have to manage unpaid FMLA know that it's very challenging. And this just adds the additional layer of immediate eligibility for this paid FMLA, as long as you meet the very minimal, as long as the employee meets the very minimal wage threshold, just over $2,000 in that 4 out of the last 5 quarters, I believe it is. And so it's going to create it's going to make the workplace for the employer much more volatile. You can see a situation where employees are in and out all of the time. And already employers who are managing and implementing unpaid FMLA see this issue. The other thing that's very interesting to me from a legal point of view is this additional 2 weeks for pregnancy-related conditions. Connecticut is one of the few states in the country that has an accommodation requirement for pregnancy-related disabilities. And I have ongoing debates with my colleagues, and there's a lot of litigation over this. How long of a leave is a woman entitled to if she has a pregnancy-related disability? Is it the full 9 months? And do you need to hold open her job for the full 9 months? Or can an employer take the position that the paid leave now is 14 weeks, and so that's the maximum? I think that could be a difficult position. That puts the employer in a very difficult position. So I think it's risky to say, okay, we've provided the paid FMLA, we've provided all of the FMLA benefits. You still have to look at the additional leave laws that might be unpaid and that require the job to be held open. So you are absolutely right. From a compliance point of view, there are numerous benefits and entitlements that need to be considered. One thing that's very clear under the new paid FMLA is that it doesn't have to apply to someone who's on workers' comp. So that's a bright line rule that's in the statute. They're now separate. You don't have to worry about applying paid FMLA to somebody who's on workers' comp. Those are two separate things that are not coextensive, and you don't have to do that. But do you have to consider, can you as an employer apply PTO, accrued PTO, to make up the difference between the employee's full salary, and especially those at the higher end who are going to be capped out? Can they apply their PTO to give them 100% paid leave? And the answer is yes, except for 2 weeks. So you have to know all of these different ins and outs when you're implementing and managing these programs. And from a compliance point of view, many of these leave entitlements, the ADA, the Pregnancy Act in Connecticut, even federal PDA, the unpaid family leaves, they all have private rights of action, meaning you can get sued in state or federal court if you don't do it right. The state paid FMLA will allow the employee to go to the Connecticut Department of Labor and bring a claim there. So, the compliance issue is very important. And, it's just going to have to, the paid FMLA has to be considered along with all of these other leave entitlements.
Thanks, Tricia. Yeah, definitely a complex area. Next slide, Joe, please. Thank you. So let's talk a little bit about benefit design. So obviously there's a ripple effect anytime there's a regulatory change of this impact, of this size, I should say, and it impacts a lot of your other benefits. So short-term disability, for instance, Randy mentioned that the cost is going to come down 20 to 50% or more, even in some cases, depending on the structure of it. Sick pay, paid time off, all those interrelated things that this domino effect is going to push. We really encourage some very tight reviews on all this. And Trish, I don't know if you had touched a little bit on the PTO and sick, but if you want to maybe talk a little bit about how you're seeing employers start to think through structuring things as they get towards 2021, or I'm sorry, 2022.
Yeah, and I think, again, with regard to the structuring, everyone needs to review their handbooks, because most handbooks are going to be, most of them will already address whether PTO must be applied to the unpaid family leave, whether federal or state. And it's a good practice, as we know, because then it requires somebody to use their PTO, and they don't get to dovetail unpaid leave with then taking additional time for PTO. So you can run it concurrently, which is a good practice. And the paid family leave will allow you to run it concurrently, except for 2 weeks. And so that's where you have to preserve for the employee the 2 additional weeks of PTO. So I think that, it's before January 1st, 2022, everyone has to look at their handbooks and their policies with regard to integration of benefits and what they're able to use. Randy, you might be able to speak more to the issue of short and long-term disability, but I believe I read somewhere that I think paid family medical leave has to be exhausted if the person's eligible for it before short or long-term disability would kick in. Do you know anything about that?
I don't, Trish, but I know that I guess the best way I can answer that is that for the short-term disability, as an example, it's a dollar for dollar offset. So to me, that says, they're looking at, the requirement is that the family leave portion has to be, I think that is a way of actually answering it. It's got to be exhausted before short-term disability will pay.
Yeah, that's what I've read. Yes, that's right. That's what I've read.
Yeah, we're on the same page.
Yeah. So, employers can still have their short and long-term disability plans, which I think actually they're great benefits for employers to have. In my experience, honestly, short and long-term disability plans help hedge against any sort of disability discrimination claim. If the employer has those disability plans, it just helps ease a person out who might be unable to work because of the disability, and they're provided with, some income to protect them. So I have to say I'm a proponent of that. If employers, can manage to provide that as a benefit, it's one of the best things that they can do to help protect themselves from liability as well. Sick pay, we know that Connecticut has a sick pay law. Many employers have the sick pay that is just as beneficial. As long as your PTO policy is as beneficial as the required sick pay, then you can integrate that into your PTO and you'd be in compliance. And again, you can apply it to the paid family medical leave as long as the employee is able to retain 2 weeks.
Hey, Ryan, we've had some conversation in the office about a lot of our clients have voluntary short-term disability, right? So, that's going to be a lot of retooling with respect to benefits as we look forward. A lot of your lower paid employees that oftentimes will buy short-term disability through payroll deduction, where the employer is sponsoring that through Colonial or Aflac or others. That really needs to be looked at. And those dollars might be able to be reallocated on behalf of the employee to something far more impactful, as opposed to keeping the plan they've always had. Now that the new law is intact, they might be able to put it into their 403B plan or life insurance or an accident plan to offset their deductible. Any thoughts on that one?
Yeah, I mean, I think first for the employer sponsored short-term disability, I think what Randy said rings true, that there are going to be some savings there that I think, when you're looking at private versus state, I think that you really need to pull in all of the information and then make your decision, not just, okay, it's 30% more than the state, but, again, if your short-term disability costs are coming down, are you reworking your sick pay and your PTO where there's potential sort of less cost to you in a given period there? Are there dollars that you can find to help offset the cost, right? Even though it's more, I don't think this has gotten far more complicated than it's the same or less than the state will go private. If it's more than the state, we'll go with the state, right? I really think that you have to pull all the information in and look at this. Short-term disability, I already know one large carrier is not actually going to be offering voluntary short-term disability anymore. And so that I thought was really interesting. And I think some of the other carriers that are traditional voluntary carriers are not playing a wait and see necessarily, but I think they're really still trying to figure out how they're going to position the voluntary the voluntary short-term disability products and what they're actually going to look like. When it comes down to it. But I do know one large carrier actually already eliminated voluntary short-term disability.
Ryan, that's a very interesting development for me to hear from a legal point of view and advising employers because, again, as I just said, I mean, this is only a 12-week or possibly 14-week benefit, right? And short-term disability has traditionally been a longer benefit, and it then dovetails into long-term. So is the result going to be that if employers can't purchase the short-term disability product, that employees are left with some period of time where they have nothing?
So Tricia, they're not eliminating traditional employer paid short-term, they're
Okay.
eliminating voluntary. So where an employer says, we're not going to pay for it, some employers allow people to buy voluntary short-term,
Right.
even when they offer employer paid.
Okay.
Some people 60% to a number is not enough. And so you'll see them purchase a policy where they may be able to replace 80%, even 90% of their income.
Right.
But when you think about that, right, when you've got something like that alongside this, I think there's a lot of fear in that employees are going to make more to be out of work than they would at work.
Right.
And
Right.
I think the nonprofit organizations, the reality of it is there's such a large percentage of minimum wage or close to minimum wage workers that they're replacing such a high percentage of their income. There's going to be high utilization on this anyway.
Yeah.
And I think that's why some of the organizations we're seeing the pricing. I think in most cases it's going to cost more than the 0.5% with the state. But there's all these costs associated with it that I think need to be factored in, and where can we work together with our clients to find money to help pay and offset that additional cost, if it makes the most sense for them.
Mm-hmm.
But I think, and we may get to a slide, so I don't want to jump the gun, but I think when I look at this and some of the observations I've made through conversations with employer groups is I would argue that not one employer that we work with, and if there is, please speak up on the phone, but not one is actually excited and wants to manage this internally, right? I don't think anybody's saying like, bring it on, I'm ready to do it. I think number two, when you look at our client base being predominantly nonprofit organizations, I think you have a really dangerous combination of understaffed human resource departments and a population that, again, when you're replacing 95% of your income and to be out on leave, a population that's going to have a higher utilization than most. So to me, that's a really dangerous combination when you look at the potential compliance issues and an understaffed HR department that has to manage this, and a lot of people using it, coming in and coming out. It probably makes more sense for the organizations that we work with to be in a private plan than anybody, right? I think, you look at organizations, not to call you out, Tricia, but like a Murtha, Cullina, right? The Family Medical Leave Act is not going to replace most of your attorney's income nearly enough that they're going to say, I'm paying for this, I'm going to use it. And that's the other part, right? They're paying for it.
Right.
So I'm paying for this, I'm using it. And when it replaces such a high percentage of your income, I think you're going to see high utilization. And the more utilization, the more opportunity you have to make a mistake and have that compliance violation.
No, I totally agree with you. This is the way the compensation structure works is, to your point, the lower wage workers have the higher incentive to use it because The maximum benefit, if I did the math correctly, is only around over 10,000, slightly over $10,000 for the 12 weeks. If you, it's minimum wage, I think times, I forget what the math is, but it's not a lot of money for a high wage worker. So to your point, there's going to be the potential for the lower wage workers to have a high incentive to use this, and they can use it as long as they've met the minimum threshold amount of compensation. So it's going to be, it could easily create a revolving door type of situation. And that's the risk.
And I think, you know, from just I don't think it takes an underwriting background to understand that the private insurers they're obviously going to price it the right way, right? They have super smart people that are doing this behind the scenes, actuaries and underwriters. And if organizations want to pay more, that's great. I think so. I think fair amount will. The ones that don't are going to go to the state. And I think the state is obviously going to end up with, you know, the majority of sort of the bad risk, if you will. And so we'll see what that, you know, does long-term to the state plan. And that's, you know, that's why I asked Randy if I think it maybe even makes the private plans more attractive if the private carriers are going to have access to utilization data a year and a half from now. So if you just say, I'm just going to go to the state and see what happens. Well, if you have high utilization and you know, people are sort of abusing this benefit, when you do want to maybe flip to the private market, are you going to be a hot potato that no one's going to want to touch, right? Because of the you know, the data behind who's using it and how often they're using it. So there's just a lot that goes into this. I think it's a lot of in the 8 years I've been doing this on this side and on, you know, on the retirement side, I think it's one of many very well-intentioned laws that have some significant unintended consequences. And I worry for our client base and for the nonprofit, you know, being on the board of a nonprofit, I worry about our organization. It's, you know, most of these organizations already have 10 or 15% open job positions. And if you get another 5 or 10% of your staff out on leave at any given time, I think it's, you know, when you think about what is on an HR team's plate, managing, you know, the day-to-day workforce is part of that. So if you're not only managing the you know, fair amount of your folks out on leave, but then also trying to manage the gaps that those people being out leaves in your organization, that is just, to me, it's going to be borderline a full-time job. And you know, I don't work with very many organizations that have an HR that is fully staffed to just handle this. Like Randy said, there's organizations that have that, but I don't work with many of those type of organizations.
And just to put this in a little bit of concrete context, because I was thinking about the numbers, if the applicant's base weekly earnings are less than or equal to Connecticut minimum wage multiplied by 40. So in January of 2022, when this is implemented, the Connecticut minimum wage is being increased to $14. So if the applicant's base weekly earnings are less than the $14 multiplied by 40, then the weekly payment benefit will be 95% of the covered employee's base weekly earnings. So that's kind of the wage or compensation area that you're looking at for the 95% covered, 95% of the covered employees' base weekly earnings. And to your point, those are the employees that are going to have the highest incentive for utilization.
And they're paying for it. You know, that to
Right.
me, maybe the biggest kicker, right, is that it's going to be coming out of their paycheck. And I'm not sure people, you know, realized that, right, until they got their paycheck and saw that it's down. And, you know, remember, I mean, that population is one that, you know, a $10 or $15 deduction from their paycheck is noticeable. You know,
Right.
they are in many cases living paycheck to paycheck. And I think, you know, they see that they're paying for it. Again, it just incentivizes them to use it even more. And I worry about the unintended consequences that this is going to have on nonprofit organizations that, frankly, you know, the nonprofit I'm a board member, we have group homes. We have to have 24-hour coverage. these folks have to have certain licenses and certifications, and I think it's going to be really, really difficult for them to manage.
And to give this the end range for this is that the benefits are capped. The total weekly benefit payment is capped at 60 times the minimum wage. So as of January 1st, 2022, 60 times the $14 is going to be $840 a month.
Yeah,
So
that's why I use Murtha Cullina as my example. Right?
Exactly.
Yeah.
I mean, and it's not just lawyers. There are a lot of people who are not going to be incentivized by $840 a week cap, but then there are a lot of people who will be. And so, and it's not to say that people will be abusing the program. It's to say that it's a benefit that is supposed to support employees. And if you really do need this benefit and you are a low wage worker, you will want to use it. And why not? To your point, you're paying for it. On the other hand, it's being subsidized by everybody who's paying into it who won't be using it. But that's how it's designed.
And that's, that gets to the point of, I think it's a well-intentioned law. I think when I look at, and again, this is not something I'm making up. I do a lot of open enrollment meetings. I have a lot of one-on-one conversations with employees. Again, being on the board of a nonprofit, we have and I'll just speak to the organization I'm on the board of because I sort of know the demographics. We have a higher percentage of single mothers than most. We have a fairly high percentage of single parents that are also helping kind of manage and maintain their parents' lives as their parents get older. And what an awesome, law to have in place to allow them to be able to take care of their children, take care of themselves, take care of their parents, and have their income replaced. Now, unfortunately, I've also seen the other side of it where, even on the short-term disability side, that it gets abused and it gets taken advantage of. And, I would love to think it's not going to happen, but it just is. And I think that's the reality of it. And, I'm not sure I've been comfortable when we've had conversations with the state and when they were part of this. I'm not comfortable with the answers that they've given around how they're going to kind of police that and manage that. It really doesn't seem like they have all that much in place. And that would make me a little bit nervous.
I can tell you from experience with regard to the unpaid FMLA, it's extremely hard to prove fraud. And here, the benefit is so generous in terms of the people that you can take it for and the reasons for it that, I'm with you. On the one hand, I think it's a really good thing to have to protect low wage workers, who find themselves in such difficult situations, due to no fault of their own. They're hardworking, but whenever you have a benefit, you may have the employee who takes advantage of it, and that's always unfortunate. I'm hopeful that it ultimately, does help the people who need it, and that employers will just have to figure it out. As I said earlier, the only thing employers do need to know is that if an employee is taking only paid family leave because they've been there for less than 3 months, then you do not have to hold the job open under the law. That's a big difference between the unpaid family leave. So that's where employers have to be really careful, because if you have somebody who's been there for 3 months and 1 day, they're going to be eligible for the unpaid Connecticut family medical leave as well. And you're going to run the paid family leave concurrently with the unpaid. But because they've been there for longer than 3 months and they're eligible for the unpaid, you have to hold their job. They have job protection. So this is where the trigger under the unpaid law used to be a longer period of time because the employee had to be there for at least a year. Here, the employee only has to be there for 3 months to qualify now for the new Connecticut unpaid family leave protection, which is job protection. Paid leave, no job protection, but you have to, that would be day 1 up today, just short of 3 months. 3 months is the trigger for the paid. So there's going to be a situation where you have a fairly short-term employee of, 3.5 months who takes their paid and unpaid concurrently, FMLA, and you, under the law, have to hold that job open. To me, that's the biggest burden for small nonprofits.
Hey,
Totally.
Joe, can you turn the slide and we can start to talk about, what we think should be being done about this? I mean, the law is the law, right? We just talked about how disruptive this is to all of you managing your workforce, right? The continuity of workflow, replacement, recruiting people, scheduling, all of this kind of stuff. And we think there's a place to really look at the culture of an organization. And we work with hundreds of nonprofits, and you can almost feel when you walk in the door of certain nonprofits, the culture. And I think it's a time where it's worth paying attention to this and maybe restructuring benefits or conversations or the way you work with your employees as we're starting to come out of this COVID situation. It's an opportune time to really look at how an employer interfaces with their employees. And, better cultures have better outcomes. This quote, treat employees like they make a difference, and they will, is a great one. And so we're starting to spend some time on things like emotional wellness and social issues, diversity, equity, and inclusion, and creating a workplace that is inclusive and all those things so that that employee, regardless of where they are on the income spectrum, know that that employer cares about them. And will they be less likely when it's gray to take advantage of sort of the liberal definitions on some of these laws? Maybe, but we think it's worthy of some time to focus on this. Randy, I don't know if you're seeing any of that. I mean, you guys are in the business of managing claims.
Right.
And, I think an employer is going to have to make a judgment call. Do they want to have it done by the state, which might be more liberal, or a firm that does nothing but manage claims? So, and the cultural impact therein. So throw it out to you guys for further conversation on maybe how to improve culture. And if any of you folks in the audience have some ideas on this, I think it's an area that should not be overlooked.
Yeah, Rollin, I think where the rubber meets the road for the employers, and it's not an easy decision, is at what point do you decide the risk mitigation outweighs everything else? Because listening to Tricia's commentary, there is so much potential for overlooking or just not being able to keep up with all of the regulations and the leave laws. So turn into a carrier, whoever the carrier is, turn into a carrier and putting your trust in them, knowing that they've got a background doing it, that they know what they're doing, they know how to keep up with the compliance, and they'll be a partner, not just for 2021 and 2022, but beyond, and they'll stay on top of it for you, on behalf of you. Some of it obviously comes down to budget, and that is a huge part of the decision. But there's also that long-term view, the long lens, and I think that is where it's going to be interesting to see how many employers decide to, quote unquote, just go with the state as opposed to dig in more, do some research, ask what the financial ramifications really are of a rate that might be slightly higher than the state rate. And if you turn to a carrier for the absence management services, what does it mean? What's the scope of services included with that? So I think that those are all significant, important considerations. Brian brings up a good point about possible unintended consequences of this state plan being rolled out, but it is here, it is not going away. And listening to Tricia talk, it really does shine a light on some of the potential pitfalls that exist, and they're real.
Can I underscore Rollin's point too about employee engagement, the culture of the organization? There have been studies that show that employment workplaces with high conflict, with lack of respect, where employees don't feel heard, those are the very same workplaces that have higher rates of utilization of leave, for example, because frequently it's tied to employees feeling stressed out. So they need, they may have some mental health issues that are exacerbated in a conflict-ridden workplace. And so what is the way to address that? And the way to address that is to ensure that your employees feel engaged in the workplace, engaged in the commitment that all of these nonprofits have to good causes, that they feel heard, that they're treated with respect, that their accomplishments are recognized. Many studies have shown that people don't just want to raise. And this is why people go to nonprofits. They're working for the cause, for the organization, and they feel good about that. So in this environment, it's particularly important to support employees to implement these really good management techniques where you're asking employees, how can we make your job better? What can we do to help you feel more engaged in work? And those kinds of discussions with employees, and particularly in the remote environment, I've had a lot of employers who have been very creative. They don't just do cocktail hour, Zoom cocktail hour, because they don't want to have it focus on, a drinking culture. So what do? We've had like a remote bingo. We've had some kind of neutral, board game that people might be able to play, or just some conversation focused on, health and wellness, bringing somebody in who can talk about giving yourself a break, mindfulness, all of those kinds of things that are very low cost to employers, but help increase the employees' feelings of engagement and satisfaction with the workforce. So I think Rollin has raised a really good point here that this is the best way, the lowest cost way that employers can ensure that they have an engaged workforce, it's a happy workforce, and that's going to result in lower liability for them with regard to employment claims. I mean, what we see is claims, for example, of harassment usually start with conflict and unresolved conflict. And again, that goes right into leave entitlement because they feel stressed out and they take the leave and they overutilize the leave. So I think all of these things really do come together, and so employers can say, what can we do that's low cost but helpful? And these are the kinds of things. There are a lot of resources online for, especially in a remote environment, how to keep employees engaged, how to ensure that you have that strong culture that where people will want to work here and want to stay in the workforce. That's what we're aiming for.
And so Tricia, I can't let the opportunity pass by without sort of giving the Schuster Group a little bit of a plug here. We have worked with Connecticut. WellSpark is a Connecticut break-off company. They have a great wellness program that focuses not just on physical wealth, but also your mental well-being. And through our TANGO organization, we've negotiated really strong nonprofit pricing. And I think programs like that are going to show your employees that they care. And I think, I think in a practical way, I really, I try to be, I am an optimist, but I am worried about this law. And I do think that the slashing of nonprofit development budgets over the last several years is going to rear its ugly head with this law, I think. And I think you know, again, I think you're going to see it right down to certain departments. People under certain managers are going to tend to use this leave more often. And I think, you know, again, that development budget is forced nonprofits to not necessarily be able to train their line staff managers as well as they probably should. And they just don't have the time or the funds to do it. And I think, you know, people's direct managers are kind of who they rely on and who tend to be the ones that either resolve or make that conflict worse. And so I think you're going to see some of that be a little bit of an issue, kind of that lack of development. I think, you know, these wellness programs that focus on mindfulness and are promoted within the organization are going to be more important than ever.
I totally agree with you. And I think to your point, it's definitely the line managers who set the cultural tone. And so, but there are ways for employers to manage that and to ensure that their managers are being trained correctly in how to manage people in an appropriate way that's respectful of the employees, and tone and language and how people treat each other in the workplace is all very important. It's within the control of the employer and it's a low cost proposition. But to your point, the Schuster Group's benefits and even these kinds of programs are so helpful to employers. So those are the kinds of opportunities that they need to look to and you know, take advantage of in this kind of environment. So I agree with you.
Yeah, it's a huge part of the conversation. So we're getting close to the end. One more slide, Jill, please. So as we look at this, what we've created internally is kind of a 4-way action plan where we're really sort of a checklist format where we're looking at compliance process, benefit design, costs, and culture. And I encourage all of you to do that and look at your workforce and kind of go through an internal checklist on all 4 of these areas of focus. And at the end of that, I think you're going to have a much smoother alignment with these new laws. And of course, the Schuster Group is here to help any of you. We would love to show our stuff, if you will. We've put a lot of time and thought and energy into this. And with our new partnership with NFP, we've got a lot to bring to the market. So I think there's a couple minutes left that we should open it up to some questions. If anybody has anything they want to ask the panelists here, we are more than happy to cast our opinions and expertise out to you. Okay. All right, guys. We're pretty much right on time. Well, I want to thank our panelists for carving out a good chunk of their day to prepare for this and be with us. Tricia, Randy, Rye, Gil, thank you. And then all of you that attended. This is the 3rd in our 3-series session on the Connecticut Paid Family Medical Leave Act. But we are obviously following this very closely. And as we move forward, we will be bringing more resources to you. And I will say one last thing on culture. For those of you that are looking for a way to help kind of build some positive feelings around your organization, remember the TANGO has a foundation, and we're going to be drawing our Rising Star Scholarship Award winners in the next month and a half and award them. And we're looking at April having a kind of an award ceremony. If you have a rising star within your organization that could use some additional training, we have money to fund that. We're trying to help groom that next generation of leaders within the nonprofit sector, and our foundation has money to give. All you have to do is go to tangoalliance.org and pull up the Tango Foundation site, and you'll see an application to apply or nominate one of your employees. So we welcome that. We have quite a few in, but we're going to be focusing on that over the next 30 days and planning for our award winners in April. So if that would help, we'd love to be part of that. So without any further ado, thank you, everyone. good luck managing all this, and we're here for you if you have any questions. Have a
Thank
great
you.
day.